Hi guys, it's Kathy. I hope you're doing well. We made it to Saturday. Today is all about comfort. Period. This is the oldest piece of clothing I own. It's older than my children. I had to open and close yesterday and it was not planned. Another server got sick. And today I open and close. But I get 8 weeks off soon, very soon. I think the 3rd is the last day, the last show we have, and then they go into the cast goes into rehearsals for the upcoming season, the next show. So they don't need servers for that. So happy birthday to your son, Sandra. That's so cool. Maya, yeah, I know. Linus, I got an idea though. Listen to this. 8 weeks. I'm going to be off for 8 weeks. So technically, January 3rd, I am not employed anymore. Right? Not employed. So guess what I'm going to do? I'm going to apply for health benefits. I'm going to tell them I'm not employed. Because I'm not employed. And I'm going to get health benefits. Oh, I think if you get the health benefits and then you're employed again, you keep them for a year. I'm going to tell them as soon as I'm employed again. I'm going to tell them I'm employed now. And if they go away after 8 weeks, that's fine. I'm so excited. They're going to deny me, but I already know they're going to deny me. But I'm going to try. I'm this close. I'm going to go see a doctor. That would be cool. My son just turned, his birthday was just a couple days ago, Sandra. He worked that day. And I went to pick him up. And there's a bar where he works. He works at this real nice hotel. In this real nice restaurant. So I go to pick him up. And the bartenders there, they're elite. I secretly recorded one of them without him knowing for like one of these drinks that he was making, because it was a whole show. It was so good. It was elite. So I get there the night of my son's birthday, and I'm like, are the employees allowed to drink here after work at the bar? Because, you know, a lot of places you're not allowed to do that. And he misunderstood me. And he thought I was asking if I could buy my son a drink while he was working. No, I didn't say that. Why would I get my son a drink while he's working? What kind of mother gets their son a drink while they're working? Anyway, so he's like, no, you can't do that. Yeah, I will, Florida Punk. I will. I'm excited. So the answer was no. So on my son's birthday, I didn't get him a drink after work at the bar right there. So then I come in the next day, or I don't know, 2 days after. It doesn't matter. And he's like, yeah, you can buy your son a drink after work. I wanted to on his birthday. I still did. I've got a blister right here from rolling silver. Now I have to wear a bandage all day at work. I hate that. And I have a ton of silver to roll today. Two-person consent for what? I missed something good, because that sounds good. Clocked out is clocked out, but a lot of places, some places you have to get changed into a different outfit first. Other places, no, you're not allowed to drink where you're employed. I've never worked at, oh, that's not true. I can't. Okay. The place I work at right now, they don't do shifties at the end of the night. No. We don't have a drink at the end of the night. If I go in and watch a show, I can. And I have. Because they have these great big goblets. Great, big, huge, like, fish bowls. Of course I'm getting that. Give me that. That's for me. So today, if my voice lets me, I don't even have to talk because we got 3 choices from yesterday. Judge Fish. Now we're going to start with him because look, we have a new view of his courtroom and taping. It's not like private. I'm out at a bar. People tape things all the time at a bar. If I find it, I'll show you guys. I'm not going to try to find it right now, though. Today's all about comfort. Today is about using the least amount of energy possible before work starts. But, okay. There's this one kid at work. He's like 22. He might not even be 21 yet. The more I think about it, he might still be in high school. I think he is still in high school. It's hard to tell with boys because once they hit like 17, they look 30. But he went in on his own time and just hung up all these little stockings all over the break room. Sorry. With everybody's name. And then he printed off these little candy canes. Alright? And then your coworkers, if they want to, can leave you little notes on coworking. On your coworkers can leave you little Christmas notes. So I went in yesterday and I had all these little Christmas notes, and they're so good. They're so good. Workhorse. They call me Workhorse. Breath of fresh air because I work. And like, you took the server position and you work and you do the you do the work. So that was really nice to go into yesterday before I found out that I wasn't getting out and I had to close. It was really iffy. Yeah, he didn't know I was doing it. He had no idea I was recording him, Kelly. I didn't say, hey, I'm going to record you right now. I said, oh my God, what are you doing? And then I pretended to play Candy Crush. Do. I do, Lena's. I think hot water, that's comfort. Hot water is comfort. Oh, Sandra, you would have such a good time. Like, Ethan. Poor Ethan. I work with this other server named Ethan. He'll be across the dining room. He'll be talking to a customer. And I'll be over at my table. And I'll shout over, Ethan. Ethan. Do we have any eggs? We don't have eggs. I mean, it's a buffet, whatever. Or something stupid. And he's like, he'll get really annoyed. He'll look over and get really annoyed. Because he's trying to talk to his table. But it's fine. You would have fun. I have fun. I have fun at work every single day. It doesn't matter who I'm with. It doesn't matter what I'm doing. It doesn't matter what job I'm doing. It's not this job. It's any job. Because why go to work if you're just gonna be, ugh, I don't want to be here. Oh, what time do I get off? You know, that's not a good way to live your life. No, you can have fun at any job, especially recording court videos. Let's have fun. I bet we get a DUI. No, this courtroom, we have a new view of it. We normally only see fish. Now we see the new courtroom, and it looks to me like, and I don't know this, he just started streaming, but doesn't this, see how white it is? Doesn't it look like this is one of the new ones? Remember Hell Court? Can't remember her name. It doesn't matter. She moved. Teresa. Nope. She moved to a different courtroom, and it was all white. Yeah, but you're not outside. You can record things outside all the time. You don't get a reasonable expectation of privacy when you're in public. When you're in your home, I would not record him in his home. Unless he's doing something really cool, then I would. But if someone's going to be GOAT, then they should not expect to not be recorded. He was GOAT. He was an elite server. Alright. I mean bartender, not server. Let's go.
We're adjourned. Yeah, good day. Good luck to you, sir.
Have a Merry Christmas to you.
Good day, sir. Does that cover you, Mr. Pribble? Is Amanda Wojcicki here? Amanda Wojcicki's case was continued. Mr. Simcoe filed a motion a couple different times. I denied it a couple different times. They called this morning, and I'm going to set him over, Mr. Prosecutor, until that January 30th date. Do you have any objection to going out that far?
I do not, Your Honor.
Okay, we'll go to January 30th at 9 a.m. Ms. Spence, you have a matter for Corbin Marshall, and you were first in the courtroom today, aside from Mr. Pribble, who's been working hard since 08:30.
He is military currently, this judge. Don't know what branch.
Probably not. I'll just leave that between you two. I would never do that if I had the option. No. Go ahead, state, please set our record.
Thank you, Your Honor. This is State of Indiana versus Corbin Marshall. The cause number is 64D01-2509F69968.
But Cristofino is in Indiana. I love Cristofino. And he's like, okay, it's 8:30 a.m. is your next court date. And then this judge, Indiana, he's like, okay, he's been here since 08:30. Where's Bobby? I need to know if anybody in Indiana just says what time it is normally. Anybody?
Defendant appears in court in person and with counsel, Ms. Katrina Spence. State of Indiana by Gary Garman.
Yes, ma'am.
Your Honor, if we could just get a new date, we do have a possible resolution in this matter that my client needs to address some issues with the office first.
We're set on January 16th already. Will that suffice, or do you need more time?
I believe that should suffice, Judge.
Okay. Mr. Marshall, you were already set January the 16th at 9 a.m. I'm just going to affirm that hearing date. Can't find it because I'm looking in 9 on 10 o'clock. And we'll see you back here January 16th at 9 as you were previously ordered. Do you understand? Yep. Okay.
The lighting in the back of the courtroom, they're not
Thank you, Ms. Spence.
they're not all even.
It is, Judge.
All right.
Look at the lights. They're all like
Thank you. Mr. Odell, you have a matter for Antonio Claiborne?
Morning, Judge.
Good morning, sir. State, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Antonio Claiborne. Cause number is 64D01-2503F62929. Defendant appears
He's on Zoom, I believe.
in court by video conferencing. Is here with counsel, Mr. Shane O'Donnell. State of Indiana by Gary Garman.
I don't know that I have Antonio Claiborne on Zoom.
He is coming from, he does live in Georgia, Judge. I believe he Should be on Zoom.
unless he's David O'Donnell.
He is not.
Okay, I don't see that he has appeared by Zoom.
Okay.
So you want to try to work on him? We'll call Jamil Claire in the meantime.
Yes, that'll work, Judge.
State, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Jamil Claire. Cause number is 64D01-2503F62934. Defendant appears in court in person and with counsel, Mr. Shane O'Donnell, State of Indiana, v. Gary Gurman.
Judge, we have an agreement if I may approach?
Yeah, please.
Thank you.
Thank you. Mr. Claire, please raise your hand to be sworn.
Sherry, good
Do you
eye.
swear or affirm under penalty of
Yes.
perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. Please state your full name for the record.
Jamil Claire,
What's your middle name?
Leon,
Have you ever used any other name?
no,
How old are you?
22,
The court has been informed that you wish to change your plea to guilty on count 2, possession of marijuana, a Class B misdemeanor. Is that correct?
yes,
Before I can accept any guilty plea, I need to ask you some questions. Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Here's Mr. Claiborne for you. Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability?
no,
Are you currently under the influence of any alcohol or drugs?
no,
To count 2, possession of marijuana, a Class B misdemeanor, how do you now plead?
guilty,
Mr. Claire, you have the right to a public and speedy trial by jury. Do you understand that?
yes,
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
yes,
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
yes,
State of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. Do you understand that?
yes,
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Do you understand that?
yes,
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
yes,
By pleading guilty, you're giving up all of the rights that I've just gone through. Do you understand that?
yes,
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. You understand that?
yes,
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. You understand that?
yes,
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. You understand that?
yes,
Possible penalty for a Class B misdemeanor is up to 6 months in jail and up to $1,000 fine. You understand that possible penalty?
yes,
You have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. You understand that?
yes,
Are you out on, are you on parole or probation anywhere?
no,
Other than this case, are you out on bond on any charges anywhere?
no,
This plea of guilty may cause harsher sentences for any future crimes. Do you understand that?
yes,
Court received a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature right at the top of the 4th page. Did you sign this agreement?
yes,
Did you read it before you signed it?
yes,
Did you have a chance to speak with your attorney before you signed it?
yes,
And before you signed this, do you believe you understood its contents completely?
yes,
As I understand the sentencing portion of the agreement, you'll be sentenced to 180 days in the Porter County Jail with all but time served suspended. You'll spend the balance on unsupervised probation and pay the related fees. You'll pay the criminal offense mandatory fee, which is a $200 drug abuse, prosecution, interdiction, and correction fee. Is that the entirety of the sentence as you understand it to be?
could you repeat that?
Which part? Is that the entirety of the sentence as you understand it to be, or do you mean to repeat the sentence?
Sen,
The sentence?
yeah,
It says that you agreed to 180 days in the Porter County Jail with all but time served suspended. You'll spend the balance on unsupervised probation and pay the related fees. It also says that you'll pay the criminal offense mandatory fee, which is a $200 drug abuse, prosecution, interdiction, and correction fee.
yes,
Is that what you recall?
yes,
Is that the entirety of the sentence as you understand it to be?
Yes.
Okay. Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No.
You understand you'll get credit for your time served awaiting disposition of this case?
Yes.
You understand I'm not a party to this agreement, but I'll be bound by its terms at your sentencing and with respect to any possible future sentence modification.
Yes.
Your attorney is going to ask you some questions to establish what we call a factual basis for the plea. Please give him your attention. Mr. O'Donnell.
Thank you. Jamil, I'm going to ask you a couple questions to establish the charge of possession of marijuana. You admit that on or about March 17th, 2025 in Porter County, Indiana, you did knowingly or intentionally possess marijuana,
Yes.
and that is a Schedule I controlled substance. Is that true?
Yes.
And the marijuana was found on your person. Is that correct? On you?
Yes.
And you knew that the substance was marijuana at the time you possessed it. Is that correct?
Yes.
And you do not have a prescription for marijuana. Is that correct?
Yes.
I have no further questions.
State.
No questions, Your Honor. Would offer the affidavit of probable causes for the factual basis as it relates to count 2.
We'll show that admitted. I don't have any additional questions. Court finds the defendant understands the nature of the charge against him to which he's pled guilty, that he understands the possible sentence for that charge, that his plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. We're going to move into sentencing state.
Yes, if we may.
Okay, we'll show the waiver of the pre-sentence investigation. Anything for sentencing, Mr. Prosecutor?
No, Your Honor. Thank you.
Anything for sentencing, Mr. O'Donnell?
Judge, we would just respectfully ask the court to accept the agreement. He does not have any prior criminal history.
Okay, thank you. Mr. Claire, anything you'd like to say before I rule on the case?
No, sir.
Okay, this time the court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on count 2, possession of marijuana, a class B misdemeanor, dismiss count 1, send you to 180 days in the Porter County Jail with all the time served suspended. You'll spend the balance on unsupervised probation, pay the related fees. You'll pay the criminal offense mandatory fee, which is a $200 drug abuse prosecution, interdiction, and correction fee. There was a bond posted in the case. From the cash bond, the court will retain court cost, probation initial administration fee, jail booking, sheriff's death benefit fee, the mandatory fee. The remainder will be paid to counsel on a bond assignment. I have time served in this case. I think arrested on March 17th.
Yes, Judge.
And then I show a bond form was filed on March 18th. So 2 days credit.
2 days. Yeah, 2 days, Judge.
Okay. And Jasmine Curl posted the bond. It looks like she has offered a digital signature on your bond assignment. We'll pay the remaining bond back to counsel on the bond assignment. Sir, I need you to go from here to the probation department. You know where they're located?
No.
Were you on pretrial?
No. he was-
Okay, you need to just walk out the courthouse, veer left down the sidewalk, halfway down the block on the left-hand side, 157 Franklin Street, you'll find the probation department. It's in the old jail, and get started on the terms of your probation, okay?
Thank you, Judge.
So that'll be your stop after this. You understand that?
Yes.
Any questions about anything?
No.
I don't expect to see you back,
Yes, sir.
okay? Anything, Mr. O'Donnell,
That's all, Judge. Thank
for the
you.
state?
No, Your Honor.
All right, we're adjourned. Good luck to you, sir.
Here's the address you go to. And you'll just check in there real quick. All right, call me if you have questions. I'll be also in about a year. We're try to get.
Okay. Appreciate it.
Good luck.
State, let's go back on the record for Antonia Claiborne.
Did you want me to set the record again, Your Honor?
I don't think it's necessary. We got it.
Thank you.
Good morning, Mr. Claiborne.
Good morning, Your Honor.
How can I help, counsel?
Wait. Stop. Don't just move on. Kelly, thank you for the cheers. Thank you. Look, guys. He's wearing a suit and tie to court. That's amazing, Mr. Claiborne. You are innocent. You are free to go, sir. Here's $100. We pay you a fine for this. Thank you, Kelly. Thank you. Monica's on a 10-day streak.
We were offered an agreement.
Thank
by
you,
the
Monica.
state. My client just needs a little more time to contemplate this. He does have a lot going on, including law school that he's applying for at the moment. So he has a lot to think about with what's going on. If we can possibly get February 6th at either 9 or 10 a.m., whatever's better for the court. And we'll have a resolution or we'll set it for trial on that.
We'll go February 6th at 9 a.m.
Thank you, Judge.
We'll have you back February 6th at 9. Sir, you're in Georgia or someplace? Is that what I heard?
Yes, sir.
Okay, you can appear by Zoom unless you hear something different from your attorney, okay?
Yes, sir.
All right, did you already take the LSAT?
Yes, sir.
Good for you. We'll see you back February the 6th at 9. We're adjourned.
Thank you,
Okay.
Judge.
What? That's on. Let me finish, Mr. O'Donnell. Julius Nagy, state, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Julius Nagy. Cause number is 64D012508F69371. Defendant appears in court in person with counsel, Mr. Shane O'Donnell. State of Indiana by Gary Gurman.
Yes, sir.
Judge, on this matter, we do need a little bit more time. We do have a pretrial conference currently set for January 16th at 9. Is there a possibility that we can move the pretrial conference to February 6th at 9?
Any objection, state?
No objection.
All right, Mr. Nagy, you were previously set in this court January the 16th at 9 a.m. I'm going to vacate that setting, and I'm going to set you over for February the 6th at 9 a.m. instead. Okay, so don't worry about January 16th, but be here February the 6th at 9. You understand?
Yes, sir.
And we'll see you back here on that date and time.
Thank you.
Thanks,
Judge.
Judge.
Do you have any questions about anything?
No, you don't have any questions. Say you don't have any questions.
No, I don't have any questions.
Mr. O'Donnell, did you get your discovery in this case?
I did, Judge.
Anything else on the omnibus?
No, Judge.
Okay, we're adjourned.
Thank you. Oh, yeah.
And then do you have Andrew Turnipseed as well?
I do, Judge.
Okay. Mr. Nagy, you can go, sir.
I'm just
Yeah.
writing it.
Oh, I'm sorry. I thought he was going to camp out for a minute.
You have a good one, man.
Merry Christmas, Your Honor.
Good day, sir. Thank you.
Please. Personnel.
Andrew Turnipseed, state.
Thank you, Your Honor. This is State of Indiana versus Andrew Turnipseed. The cause number is 64D012508F69112. The defendant appears in court in person and with counsel, Mr. Shane O'Donnell. State of Indiana by Gary Gurman.
Yes, sir.
Judge, on this matter, I need to meet with Mr. Gurman on this. If we can possibly have one more pretrial conference for February 6th at 9 a.m.
Any objection, state?
No objection, Your Honor.
Mr. Turnipseed, I'm going to set you over for February 6th at 9. In order to appear back here February 6th at 9. Do you have any questions, sir? No. Okay, anything further, Mr. O'Donnell?
That's all, Judge.
All right, sir. Thank you.
Thanks. Have a Merry Christmas.
Good day.
Jude, thank you so much.
So why is David here?
I did order coffee. It's coming about 10 minutes. Remember that that lawyer that wore the
David,
orange
you have a matter
shoes
before the court?
in court?
Judge, I thought I had Aaron Stevens set for a pretrial today.
Remember she wore those orange shoes in court in Georgia? They were not Crocs. But this guy has orange Crocs on, just like that lawyer.
No.
Well, if not, that's good news for me then.
Overachieving.
Have a great holiday, Judge.
Thank you. You want to have us look into it, or are you confident you can figure it out?
I'm confident that I was just wrong this morning.
Okay, you're going to have those days.
Thank you, Judge.
All right, take care. State, let's go with Lance Washington. Would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Lance Washington. There are two cause numbers, 64D012510CM11448 and 64D012412F612572. Defendant appears in court in person and with counsel, Mr. Nat Henson of the Public
Sherry,
Defender's
that would be
Office, State of
amazing.
Indiana by Gary Gurman. Mr. Hanson is here by video conferencing.
Morning, Mr. Henson. Can you hear us okay?
I can, Your Honor. Can you hear me?
I can. Good morning, Mr. Washington.
Good morning.
Mr. Henson, how can we help this morning?
Well, Your Honor, I'm actually covering for Mr. Elwood, who I believe is the assigned public defender to Mr. Washington's case. My understanding is that Mr. Washington, as the record reflects, has two cause numbers, one of them associated with a contempt finding that occurred back on December 5th. In my discussions with Mr. Elwood, I'm asking that the court actually reconsider the sentencing in that case and release Mr. Washington on his own recognizance now that he has had an opportunity to sit for 2 weeks at the Porter County Jail on that. And then my second request is that the matter or the matters be reset for a further status hearing.
So we didn't go on the record for the contempt case, but you made a recitation of that cause number for us, Mr. Henson.
I believe, let's see. I'm looking at the paperwork
Mr.
here and
Fish.
I'm assuming both the F6 12572 matter and the CM 11448 matter are reflected in the court's direct contempt finding. So I'm not sure if it's associated with both cause numbers or just one cause number, but I guess I'm referencing it in regards to both those cause numbers.
All right, so we're also on the record in 64D01-2510-MI-13464, which is in re the matter of the direct contempt of court by Mr. Washington, where I 2 weeks ago, sentenced him to 90 days without credit time for direct contempt. Okay, and you're asking
Thank
me
you, Your Honor.
today, you're asking me today to do what with that contempt?
I'm
case?
asking the court to reconsider its ultimate finding of sentencing Mr. Washington to 90 days in that matter. I guess sentence him to time served in that matter, and then reset the F6 and CM matters for further proceedings or a further status conference so that Mr. Elwood can get in, discuss the matters with Mr. Washington and the state.
Okay, thank you. State, any objection to a new hearing date on the criminal matters?
No objection to that, Your Honor.
Okay. How much time did you say you need for that, Mr. Henson?
If we could have 30 to 45 days, Your Honor.
I'm happy to go to the January 16th setting. I'm not sure if Mr. Elwood has anything, but I normally set him at 10.
That would be fine.
Okay, so January 16th at 10 o'clock on the two criminal matters, CM 11448 and F6 12572. Mr. Washington, a couple weeks ago, I had you by video, and at that time, I had sentenced you to 90 days for direct contempt of court. Things got a little bit heated that day. What do you have to say for yourself, sir?
I apologize, Judge Fish.
Okay, go on.
I apologize for the contempt of court. Just got heated. I didn't appreciate you telling me to behave when I'm a grown adult, 39 years old, and I've never been in the criminal system in my life, and it just felt disrespectful for me. So I couldn't contain myself.
I understand,
apologize.
sir. The last thing I want to do is be disrespectful
Yeah.
to anyone. We will remit the remaining sentence on contempt. Okay?
That mean,
It means that you've done time served for 2 weeks. We'll remit the remainder,
okay. Yes, sir.
and there won't be any further sentence.
Sir, appreciate you.
And we'll have you back January 16th at 10. It's okay? And work with Mr. Elwood. Mr. Elwood's the chief public defender for Porter County.
Yeah,
He's your
right.
public defender,
Okay, thank you, appreciate it. Yeah.
and he'll be working with you on the case going forward, okay?
All right, appreciate it.
See you back in a month.
All right, yes, sir.
Good day.
I don't think that was the guy that we just got 90 days contempt for. I think it's a different guy. So I suspect in another week, because we're about a week out from that guy getting 90 days of contempt, I suspect we're going to have an update video of him coming in and apologizing. Maybe not. I don't know.
No, you can go up here by Zoom, that's fine.
I don't know. That looks like him though, but
Judge, I believe that's all I have. I appreciate you allowing me to appear by Zoom.
I appreciate you appearing.
that looks like him. But what he just said there, and it sounded like him, but what he just said there didn't make sense. He said, I didn't like he had to pay money. The judge didn't talk about paying money during his contempt hearing. He walked in. The judge said, I'm gonna let your lawyer go, because I guess there was a problem with him and his lawyer. And do you want me to assign another lawyer? He said, no. Why? You dismissed it. You did. You dismissed it. You did. Dishonorable Judge Fish, you did. Go look at the records. Play it again. You dismissed it. And he kept going. He didn't swear, but he just could not stop talking. Judge gave him contempt of court. That really did look like him, and it sounded like him. But he didn't get any money. I didn't understand that part, but it doesn't matter. It was him. He apologized. I guess he lost his 2 weeks. Darn.
By Zoom, sir. We thought we
My
weren't gonna be able
coffee's
to
here. I'll
connect
be
you this
right
morning.
back.
Hey,
Be
Judge,
good.
real quick, while I have you, last night one of my dogs got attacked
Oh no.
by something. So I don't know if you have any animals, but given the fact that you live right behind me, just be on the lookout.
I appreciate that. I know there's a fox. We've seen the fox on our video cameras.
Yeah.
We've seen fox tracks in the snow multiple times.
Okay. Yeah. Luckily, my dog's okay, but had to have surgery last night, so it was pretty bad. So.
Oh, sorry to hear about your dog, man.
Yeah, that's
But
all right.
I think we have a fox for sure.
All right. Appreciate it.
All
Have a good weekend. Merry Christmas if I don't see you.
Thank you, sir. We'll be looking for your fireworks on the New Year's Eve.
All right. See you later.
Thank you. I think I have Rachel Armes. Stay, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Rachel, did you say Arms? Arms. Cause number is 64D012510F6118841. Mr. Arms appears in court in person without counsel. State of Indiana by Gary Gurm.
Ms. Arms, I had you in court about 11 days ago or so. I think you told me you plan to hire private counsel. That's it. How's that going for you?
Yeah, I can come with the funds.
Okay. Are you asking me to see whether you qualify for the public defender?
Yes, sir.
Please raise your hand to be sworn. You swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth.
Yes.
Okay, thank you. What do you do for a living?
I work for Porter County Commissioners and clean the courthouse.
Okay. How much do you earn doing that?
Roughly 1,600 a month.
How many kids do you have?
3.
What are their ages?
16, 9, and 8.
They're all in your care and custody then?
Yes.
Okay. Are you married?
No.
Where do you live? Do you buy or rent your home is what I really want to know.
I own
How much is your mortgage payment?
1183.
You said 1,600 a month?
Mhm.
Any other sources of income?
I receive child support,
How much?
480 a month.
Are you on any form of public assistance?
Food stamps.
You do get food stamps?
Yes.
Do you have a car payment?
Yes.
How much is that?
280.
I'll find your indigent. You qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. That's typically Mr. Steve Pribble for this court. You have a hearing on February the 27th at 10 a.m. and another on March 27th at 10 a.m. in order to appear for both of those. And we'll give you a note for this morning, okay?
Yes, sir.
Do you have any questions about anything?
How do I contact?
Mr. Pribble's phone contact information is going to be on this slip of paper.
Okay, thank you so much. Thank you.
I apologize. Thank you, Judy. I had you at 10. Mr. Pribble comes at 9. So I need you to move the hearing date to 9 a.m. We'll vacate the 10 a.m. settings, move you to 9 a.m. Okay? And we'll see you back here then 9 a.m. on the 27th, February 27th of March.
Thank you so much.
We're adjourned. Thank you. Jason Craig, state, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Jason Craig. The cause number is 64D01-2511F6-12755. Defendant appears in court in person without counsel. State of Indiana by Gary.
Morning, Mr. Craig.
Morning, Your Honor.
Looks like same situation back on December the 8th. You were in court and you told me you planned to hire private counsel. How's that going for you?
I've been unable to at this time.
Is that because you can't afford it or for some other reason?
Yeah, I can't afford it, Your Honor.
Are you asking me to see whether you qualify for the public defender at this time?
Yes, Judge.
Please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Thank you, sir. And what do you do for a living?
I'm unemployed.
When's the last time you worked?
About 4 years ago,
What have you been doing to make ends meet for 4 years?
living with my father,
Do you have any source of income whatsoever?
just get food stamps, assistance.
Is your father willing to hire a lawyer for you?
He's sick in Florida.
Does anybody owe you money?
No,
Do you have any money set aside?
no, Judge.
Are you like a trust fund baby or anything?
I'm drinking my
No.
coffee.
No?
Trust fund,
Nobody
baby.
has
You can
millions of
trust
dollars
me.
that you benefit from or anything?
Anybody, somebody, come on. Tell me what that's from. I'm a trust fund, baby. You can trust me. Come on. Somebody say it. I'm going to press play and let you guys think about it for a little bit.
Fortunately not.
All right. I'm just trying to figure out how for 4 years you could keep food on the table.
Food stamps.
Do you have a car or anything?
No,
Any other big ticket property items, jewelry or anything valuable?
no, Your
I'll
Honor.
find your indigent. You qualify for the services of the public.
I mean, it looks like he's sitting in an RV right now. I might be wrong, but does that not look like an RV?
Public defender. I'll appoint the Porter County Public Defender Service to represent you. Typically, that's Mr. Pribble. Like I say, I did the same thing in your case. I set you for the 10 o'clock settings on February 27th and March 27th. I'm going to vacate both those and make your hearing dates February 27th at 9 and March 27th at 9 in order to appear back here. at
Yes,
those days
Zach,
and
a
times.
huge
Understand, sir?
musical.
Yes, sir.
Go
Okay,
big.
We're adjourned.
Thank you.
Pick a
Good day.
big musical. That's what it comes from. Come on, you're close.
Joshua Ilgenfritz, stay, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Joshua Ilgenfritz. Cause number is 64D01-2407F6-7920. Defendant appears in court in person without counsel.
It's
State of Indiana by Gary
Hamilton.
Gardner.
Yes, sir.
How do you say your last name?
It's when Eliza meets Burr.
Soft G, huh?
Yes.
You were in court back on December the 5th for the admit deny on the probation revocation matter. You told me you were going to hire an attorney. What's going on with that?
My paychecks, my last paycheck, it comes in 3 days. It got put on hold for 2 weeks. We had new owners take over the company, so our paychecks got kind of messed up. I plan on
Hi, V.
hiring counsel with what comes in on Thursday.
You still plan to hire a lawyer?
Yes.
Who are you going to hire?
I was gonna go with Roy Dominguez.
I'm setting you until January the 30th at 10 a.m. That's a final hearing on your revocation of probation matter.
Okay.
So you do what you have to do, but I'm holding a final hearing on January 30th at 10. If you don't have a lawyer hired by then, I'm going to have it anyway.
Okay.
Understand?
Yep.
We'll give you a note too.
So where I work, I mean, there's a musical and there's another show where I work. And the staff is sort of split into two silos. We have the cast, and then we have the kitchen and servers, okay? Well, the sound engineer, he has aux. That means he controls what music plays, even when there's no show on and it's just us. He has aux. You know, it just means like the aux cord. He gets the aux cord to the speaker. In the kitchen, it's always normally a chef gets aux, and when a chef is off for the night or they leave early, the rest of the kitchen fights over who has aux, who gets to play their music. Never do servers get aux in a restaurant anywhere. But when the show's over and everybody leaves and we're cleaning up, the sound guy's still there. He's still working. He has aux. So I don't know. It was like 2 weeks ago. I asked him to play. I can't remember. Hamilton. It was Hamilton. Oh my gosh. I said, play Hamilton tonight for the cleanup, for us to clean. So now every night, he's been playing a different Broadway while we clean. And this is not great for the other servers involved. But this is fantastic for me and Nate, the sound guy. And then the cast, they walk around after the show too. So it's a huge room, you know, with the big stage and everything. So when cleaning's going on, I'm singing at the top of my lungs, off key and badly. Nate is usually across the room singing at the top of his lungs. A cast will come in and walk by or something. They'll start singing whatever Broadway is on at the top of their lungs. And then the other servers are just cleaning. But listen, Nate has aux. You can't tell Nate what to play. He plays what he wants to play. And it's fantastic. It makes cleaning go so much faster.
Any questions?
Nope.
State anything?
No, Your Honor, thank you.
David Keaton, state, would you please set our record?
Or it's very late metal. Could be
Yes,
very
thank you, Your Honor.
late.
This is State of Indiana versus David Keaton. The cause number is 64D01-2510F6-11036. Defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
GNR, yes sir.
Mr. Keaton, you were in court on October 31st
Yes, sir.
and told me that you plan to hire private counsel. Since then, deadlines have come and gone on your case. You're set today for an omnibus hearing. You don't even know what that is. And you're still sitting here with no lawyer. All you've done is jeopardize your defense. And now, what do you want me to do?
I was going to ask for a lawyer today because I lost my job.
Okay, please raise your right hand to be sworn. You swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth.
Yes,
Okay, sorry to hear you lost your job. What were you doing when you lost your job?
I was working at a factory and so
How much were you earning?
like 16 an hour,
How many hours a week were you working?
35, 40.
Did you have any money set aside from that?
No, because I was getting caught up on bills for the time that I was in jail.
Mm-hmm. How long were you in jail?
It was a few days, but I didn't have a job before I lost my job, my previous job, and then I got the job.
Do you pay for housing?
I pay for housing. I get a monthly check
From who?
from my social security.
You on Social Security?
Yes, because I have a learning disability.
How much do you get from Social Security?
1,100 and my rent is 1,100.
Okay. How do you put food on the table?
I've been going to food pantries.
Did you apply for food stamps?
Not as right now.
Do you have any kids?
No.
I'll find you're indigent, you qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. I had you set for January the 16th at 9 a.m. for a pretrial conference. State, do you have any objection to me continuing the omnibus hearing and the pretrial conference both till January 30th?
No objection, Your Honor.
That'll at least give Mr. Pribble a fighting chance on the omnibus date. So I'm going to vacate your current setting of January 16th at 9, set you over for January the 30th at 9, in order
Okay.
to appear back here, in order to contact Mr. Pribble today.
Okay.
You understand that?
Yes.
Do you have any questions about anything?
No.
Okay. Anything further, State?
No, Your Honor, thank you.
Okay. Got a note for you as well.
Okay.
Okay. So we'll see you back here in a month and a half. Jessica Staton, State, would you please set our record?
Yes, Your Honor, thank you. This is State of Indiana versus Jessica Staton. Cause number is 64D012209F67597. Defendant appears in court in person and with counsel, Ms. Robin Remley, State of Indiana by Gary German.
Yes, ma'am.
Morning, Your Honor.
Good morning.
Your Honor, we're hearing a petition to revoke probation. I had filed a continuance because my client went into intensive detox and like a mini rehab per se.
We're filing a petition to revoke probation. No, they're here for a petition to revoke probation. She's filing continuance because her client went into a mini rehab. I don't know what that is, but I freaking love mini things. I love, love, love things that are little miniatures. I don't buy that. I don't buy them. The last thing I need in my life is a house full of miniature trinkets. No. But that doesn't mean I don't love them. I love them.
7 to 10 days.
Yeah,
It's 10 days.
it was 7 days at Recovery Works.
Recovery Works in Maryville and is enrolling in an intensive program now through regional. I have not had a chance to talk to probation or prosecutor on this case. If we could get maybe a date in January to give us time to work out a solution to this.
I haven't had a chance to give her the advisement on the probation revocation. So let me do that first, and then get your calendar, look at January 30th, see how that looks for you. But, ma'am, back on October 28th, probation filed a petition for revocation of probation. In that petition, they allege you violated Rule 1 for reporting. They say that you failed to report to a meeting on October 27th or showed up late, late such that the date had to be canceled. You understand the allegation related to Rule 1?
I do now, sir.
They also say you violated Rule 4 for financial obligations. At that time, they said you were $260 behind on your user's fees through October, and then they say you owed $469 to our clerk. You understand that?
I do. I just started probation, though.
Let me go through the advisement, ma'am, and please don't add additional comment. What's important is for me to know whether or not you understand.
Okay.
Okay, and then they say you violated Rule 9 for narcotics. They attach a drug screen from a September 19th, 2025 test. I mean, it is lit up like a Christmas tree. Positive for amphetamines, benzodiazepine, no, not benzodiazepine, but cannabinoid, cocaine. Do you understand the allegations related to Rule 9?
I do, Your Honor.
Okay. Then probation also filed an addendum to the petition for revocation of probation on November 13th, 2025. They say you violated Rule 9 for narcotics. and they attach an October 27th, 2025 drug screen. And that one is positive for amphetamine and cannabinoids. You understand the allegation is related to Rule 9 from the addendum?
I do, Your Honor.
Okay, if it's found that you violated your probation, any part or all of your previously suspended sentence could be imposed as jail time. Additional conditions could be added to your probation or an additional length of time added to your probation. Any or all of those may occur if it's found that you violated. Do you understand that?
I do, Your Honor.
In a revocation proceeding, you're entitled to a hearing. At that hearing, the state would have to prove by a preponderance of the evidence that you actually violated your probation. Do you understand that?
I do, Your Honor.
At that hearing, you'd have the chance to confront and cross-examine witnesses, and if necessary, use the court's subpoena powers to have witnesses brought here to testify on your behalf. You understand that?
I do, Your Honor.
You're also entitled to counsel. You have Ms. Rimley involved in the case at this point, but if at any time you couldn't afford an attorney, we would appoint one for you. You understand that?
Yes, sir.
All right. Anything on the admit, deny?
For now, deny, Your Honor.
We'll enter denials for Ms. Staton on the revocation matters, and we'll set you over for January 30th.
Thank you.
Does that work for you?
Yes, that
10 o'clock? January 30th, 10 o'clock, final hearing on the revocation. We're going to do a final that day.
thank you, Your Honor.
Okay, we're adjourned. Thank you.
That's enough for fish today. Let's try let's go to Judge Eric for a little bit. Let's go to Eric Johnson.
Intelligently and voluntarily.
Hold on, Judge. I'm not ready yet. Jeez, premature. Sir. Oh, it's already, look at that. Zach will appreciate that. It is already perfectly sized. How often does that happen? Never. Oh my goodness. Okay, Judge, you're on. Let's go.
Are we going to immediate sentencing?
Yes, Your Honor.
Counsel?
Yes, Your Honor. The people are not requesting PSI and are willing to go to immediate sentencing. People are not asking for restitution, no additional jail. He served, I think, over 2 months in custody. He'll be on 60 days of GPS monitoring. The defendant's behavior, obviously, in this case was extremely egregious. However, the victim suffered minor injuries. The defendant has limited history and no prior DV. It appears as though he's amenable to DV and substance abuse treatment, which it seems as though this case was largely impacted by substance abuse. So I'm hopeful that the defendant is willing and able to take advantage of the opportunity at probation, and that's the people's position. Your Honor, I also have an updated MPO. It looks like the original MPO didn't have DV or VRA, so I have an updated MPO for the court as well. And I'm sorry, VRA or that a weapon was used. Those were the two things that were not checked.
Mr. Orlando?
Your Honor, we're asking the court to impose the 2 years of probation in this case with no additional jail sanction. As Mr. Santos said, Mr. Kelly has been incarcerated since October 22nd, about 2 months at this point. He is before the court on his very first arraignment, taking responsibility for the actions and the harm that he caused to Ms. Shammy. Mr. Kelly apologizes for everything that he did. He's hopeful that he could be successful on probation. He has a very limited criminal history and is looking forward to being able to participate in that.
All right, so you have the right to tell me anything you'd want me to know now.
I apologize to the victim and to the court.
All right, Mr. Orlando. So I'm handing your attorney a updated mandatory protection order. It's exactly the same as the other one that you had been advised of and that you signed. The only addition is that it notes that this is a crime of domestic violence and it's a crime under the VRA.
And Your Honor, it does state that a weapon was used and that previously had not been as well.
Okay, so that's added as well.
What's your hand?
All right, thank you. All right, so it is important that you abide by that protection order. You can't have any contact with the victim directly, indirectly, through someone else. No way. If you do, depending on how you violate the protection order, it could be a misdemeanor, it could be a felony. So it can cause a lot of problems, and it would violate your probation. If you violate probation, then you come back in front of the judge and they've got to decide whether to put you in prison. No one wants to do that. So I'll go along with the disposition in this case. I will sentence you to 2 years of
Thank you for the cheers,
probation.
Monica. Thank
Like you've
you.
agreed to a condition of probation being 60 days of GPS monitoring. I presume there are exclusion zones there?
I'm not. 1 second, Your Honor.
Don't know why we're monitoring otherwise.
Yes, there are exclusion zones. I just don't have them pulled up in front of me right now.
All right, well, you're gonna have to do domestic violence evaluation and treatment, substance abuse evaluation and treatment. Does your client have any other holds on him?
No, Your Honor.
All right, sir. So you're gonna be out probably early afternoon today. If you're out by 2 or 3 o'clock, just go straight across Caddy Corner to 303 West Colt.
Bobby, it was 30 yesterday and 60 today, right? For you? Yesterday, it was both 30 and 60 and 10. It was so hot during the day. And then as soon as the sun went down, poof, it was freezing. And the wind was unbelievable. The wind last night was really bad. But the thing is, this is what got me the most yesterday. It was pouring down rain yesterday morning. Just pouring buckets. Listen, if you live in Pennsylvania, if you've lived in Pennsylvania all your life, and you get precipitation in December, that's supposed to be snow. We had so much rain yesterday. We should have gotten a ton of snow yesterday. We just should have. And it was just way too hot. So hot. So it was all rain. Then the sun went down yesterday. Boom. Freezing cold and windy. No rain. So therefore no snow. But yesterday really, like they stole that from us. We were supposed to get dumped on with snow yesterday. And it's just not fair. Where is my snow? It was a lot of rain. We would have had a healthy snow. It would have been lovely. But no, we just get mud instead. And then the mud is going to freeze. So we're going to have frozen mud.
Colfax, that's where probation is. Check in with them and get things started. Otherwise, get to probation Monday at the latest. Okay? All right. There is no restitution, and I'm not going to impose any additional jail as a condition of probation as the defendant's already done substantial jail.
Judge, if we could call number 4, Mr. Chase Newmeyer on bond sentencing.
Thank you, Judge.
Who is he?
I'll be there at 8:30. Yeah, you can just stand up here.
25 CR 3265, People versus Newmeyer, entries.
Walzies on behalf of the people.
Nathan Hall on behalf of Mr. Newmeyer. He appears on bond in person to my right. Judge, we're set for sentencing. We set this matter over from Monday. So Mr. Aziz could get in VRA, I think, for sentencing, or at least so the victim could appear. I think we're ready to proceed today.
All right, Mr. Aziz.
Thank you, Your Honor. Our victim, Alex Clark, is online. As an initial matter, he provided me with a written statement that I would like to read to the court. We had him revise it, so I'm just grabbing the right one.
Yeah, I do roofing right now. I'm done. Construction.
My apologies. The victim states, I never met the defendant and I don't remember him because the punch and brain hemorrhages caused me to lose my memory from that night. I'm grateful that doctors got me in time to perform emergency surgery to drain blood from my brain. And he should be grateful too, because without that intervention, I would have died and would not have been able to spend time with my family again. And he would have spent prison time for decades. The doctors told us my injury was extremely severe, with the blood filling up my head quickly from the burst arteries and veins and displacing my brain by 3.5 millimeters by the time I was rolled into surgery. If the doctors had not stopped the bleeding, I would have faced permanent disability and brain damage at 5 millimeters and death at 10 millimeters from it cutting blood circulation. I feel conflicted about the event because I later saw footage showing the defendant being hit by pepper balls fired by police who were trying to break up the defendant fighting involving punches being exchanged with protesters. Because I don't remember that night, I can only piece together what happened from what I was told and what I later saw in footage. After that altercation, the defendant approached me and knocked me out, and I believe he wanted to take out his anger on the first person he saw, who happened to be me. Someone who was present that day told my friend that defendant said he was angry that protesters brought the police close to the skate park where the defendant and others were spending time. I understand why someone might be upset about that, but I don't agree, and I think it was completely wrong and immature how he handled the situation, exchanging punches with other people and then approaching me randomly to assault me once he was bruised from exchanging punches and being hit by pepper balls. He did all this instead of going home and taking his friends and family away from there. I hope he learned to handle these situations differently and walk away. I had no choice about where the protest ended. I wasn't the reason he got into a fight with people, and I did not order the police to shoot him with pepper balls to stop his fight. I did not deserve to be approached and assaulted. I was there to videotape in case someone got hurt. Because of my brain injury, I have memory issues and had to leave my partner in Denver, someone I learned to love deeply, to recover in Illinois with my family because I could no longer work. If it wasn't for my family, I would have ended up homeless from not being able to work from the injuries. I also don't know whether I will ever be able to reunite with my partner while I recover and rebuild my life in Illinois. I'm grateful the assault did not continue after I was on the ground. I believe if the defendant had continued to punch me or kick my head once, I was unconscious, my head would have filled with blood more quickly, and I could have become permanently incapacitated, lost my independence, and suffered even more severe memory loss. It was already bad since when my cousin came to visit me at the hospital to take me back home. Every time I saw him was like the first time I was seeing him.
Hi, Lacey.
I greeted him like I had not seen him in months. Thankfully, I've been recovering month by month, and I hope the defendant uses probation as an opportunity to improve and not reoffend and get into more fights. He should know he is being given a second shot at life by the Denver DA. I also understand the seriousness of what happened to me and that this case could have resulted in significant prison time of 5 to 10 years in prison for the defendant. Instead, the defendant has been given an opportunity through probation and the possibility that in a couple of years, the felony could be reduced to a misdemeanor. I did not object to that outcome because the teachings of Jesus say we must treat our enemies with love. And if he was my brother or cousin and he made an immature, dumb mistake, I would want him to have a second chance at life to learn a just lesson. If he has children, I did not want to be the reason his kids would grow up without a dad if my objection was taken into consideration. But he should know he has hurt my life and I only want him to walk away from fights in the future. If he walked away from his fight, he would have not been hit by police and would not have assaulted me randomly. He should be grateful he's been given a second chance by the Denver DA. He should also know that I am having a hard time finding work like he will with a felony for those years because of the news articles about the assault. Some employers appear worried about hiring someone who has sustained serious brain injuries, and my life has been changed in lasting ways. I'm aware that research on traumatic brain injuries like the one he gave me, such as injuries sustained in boxing and football, show that people can experience long-term effects later in life, including mental health and cognitive problems. I'm scared about what may happen to my health in the future. I hope I do not get worse, and I do not want to have to pursue additional legal action, including taking the defendant to civil court, but I may need to consider lawful options in the future, depending on how my conditions develop. He should expect me to contact him if I get sicker. I want to move forward, turn the page, and not live with resentment. I hope the defendant does better for himself and his family and takes advantage of the second chance probation provides. If there is one thing I hope the defendant takes away from this, it is this. If a situation becomes heated, when insults are exchanged and it looks like it might turn physical, the safest and most responsible choice you can do for yourself and your family is to walk away. Real life is not like the movies where violence happens and everything goes back to normal. People can be killed, families can be devastated, and survivors can live with lifelong impacts like you hurt me. A good rule is to walk away and be smart if he ever feels like hurting people in a fight. Walk away. Because next time if the defendant doesn't do that, he might just kill someone and he almost killed me, and he might just have prison walls to look at instead of being there with his family. Thank you to my Denver advocate, Jessica and Michael, for providing me resources to get back on my feet. I'm grateful for Denver's help after surviving this, and thank you to Bilal for including me in your decisions. I didn't feel alone in this process thanks to your work and professionalism. I hope you keep it up because it makes a difference in our recovery. I wish you and the members of the court and the DA the best. So, Your Honor, Mr. Neumeier, obviously, this was a single punch to the face. There was video footage before and after showing the defendant approaching the victim. There was some confusion initially because a compatriot of his was seen standing over the victim who was on the ground, seemingly unconscious, holding a skateboard. And it was thought that perhaps the defendant was struck with the skateboard. It later turned out that it was actually Mr. Neumeier punching him once. A single punch as
Neumeier what?
Mr. Neumeier caused the injuries with a single punch to the face. A single punch can result in little to no injuries or devastating injuries as the victim has sustained in this case. It's hard to sort of increase the blameworthiness of a person based on the circumstances of if he had fallen on the grass rather than concrete, if the punch had landed somewhere else on the victim. But the point bearing is that the victim experienced devastating injuries. I've spoken with him personally on a couple occasions. It is clear that the traumatic brain injury that he suffered is going to be something that he deals with for a long time. And so while this plea is mitigated and it's a split plea that allows Mr. Neumeier to potentially relieve himself of the felony eventually, this is a serious case and could have resulted in outcomes that would have changed Mr. Neumeier's life forever. In that context, and I guess the other thing I'll say is my concern, having pled Mr. Neumeier to a split plea, is how we got back to Denver. We allowed Mr. Neumeier to travel out of state He ended up having to be extradited back to Denver after he missed a virtual appointment that the court, a virtual hearing that the court approved him to appear remotely. I understand that there may have been some technical issues, but the fact remains that he was not arrested for nearly a month after that hearing and had to be extradited at that point. If there had been some technical issue that should have been handled that day, we should have been called, we should have been informed. That gives me some pause in whether he will be successful on the split plea. But I asked the court to nonetheless impose the agreement as tendered by the parties.
Are you talking about his November 3rd FTA?
Yes, Your Honor.
All right, well, you extended the offer after that.
I believe
Because
that,
he pleaded on it 12/12. You allowed him to plead on that offer after the FTA,
Yes,
after
Your
the
Honor.
extradition.
yeah,
Okay.
and I'm not asking to withdraw or anything like that. I'm just noting my concerns about his ability to comply on probation.
What's the prosecution's understanding as to why this even happened?
The event itself.
Yeah,
My understanding is this was a protest over immigration issues that
that much I worked out, trying to figure out this punch.
I believe Mr. Clower's recitation is like the likely issue is that it interfered with something Mr. Neumeier was doing. There was police presence in the area. He got frustrated and took it out on a random person. So random act of violence. As far as I know, these parties aren't known to each other. So, Your Honor, in all, based on everything that, all attendant circumstances, I'm asking the court to impose the agreement as tendered. And however, I would ask the court to consider imposing a jail sentence as a condition of probation. This, again, could have resulted in irreparable changes to both of these individuals' lives. And the defendant needs to take this opportunity seriously. And thus far, I'm concerned of whether he's doing so. As far as restitution is concerned, my understanding in my prior conversations is that much of the medical bills were covered by Medicaid, if I'm not mistaken, but we are certainly expecting potential ongoing costs. So the people would ask to reserve restitution. There is an extradition cost. I believe that the sheriff already filed that with the court. Beyond that, I have nothing further.
I do not know what the judge is going to do here. I just don't know. I feel like the longer he ponders, the worse it's going to get. Or,
Thank you, Your Honor. Mr. Neumeier is asking that the court sentence pursuant to the plea and order no further jail. Mr. Neumeier is before the court, frankly, agreeing with a lot of the statements from the district attorney. What happened that night was tragic, unfortunate, and avoidable. It didn't need to happen. Mr. Neumeier recognizes that. He takes full responsibility for that punch and is sincerely apologetic for the significant and life-altering changes he's made in the victim's life. He has taken steps to change himself for the better, with an understanding that any anger management classes that he's been taking since this incident is unlikely, frankly, to make the victim whole again. But Mr. Neumeier has been successful in his kind of own journey towards rectifying this act. He has been enrolled in an anger management program back in Ohio called Recovery Services. That's a 6-month program. He has 2 months left on that. As the court can see, Mr. Neumeier has no prior criminal history. And I think that goes to show that what was going on that night was just the tempers were flaring. There were a lot of people who were involved in this protest that had law enforcement activity. Obviously, that's not an excuse for how Mr. Neumeier kind of started getting angry and lashed out in the way that he did. I do think, though, that when someone is on their own taking anger management classes, it indicates to the court that they're on the right path to not commit, this type of senseless act again. Mr. Newmeyer obviously has been granted the ability to return to Ohio for the majority of this case where he lives. He lives with his mother, his significant familial support system there. He also is gainfully employed at a construction company. Prior to this case, Mr. Newmeyer was employed in the union. I think it was doing steam fitting work. The hope is that he could return to that union job as soon as he's able to return to Ohio. The court may recall on Monday, Mr. Newmeyer asked if he could have a court order to report to probation on Monday and get started on the interstate compact. Obviously, the court did not order that. I don't think the court had any authority, and I agree. But Mr. Newmeyer did go on his own and report to probation and ask if he could get started with the expectation and the hope that this DJ would enter today pursuant to the plea. Mr. Newmeyer understands and takes the court very seriously when they said, if you don't show up on time on Friday, this plea wouldn't be accepted, or this sentence wouldn't be accepted or entered. He got here at 7:15. He's ready to report. He understands his obligations. He takes them very seriously. And I recognize the court and Mr. Aziz's concerns regarding the FTA. I do think that was a technical issue that was unfortunate. I may have missed if Mr. Newmeyer reached out to me and asked what was going on. And so I take partial responsibility for that as well.
How's it a technical issue when he had to be extradited 30 days later?
So what I mean is missing the court appearance. Obviously, it is true. Mr. Newmeyer was extradited. He's on the hook for that expense. He will pay that. He'll also make any strides towards paying the restitution as ordered. He recognizes that he's on the hook for this. And I want to be clear, he takes responsibility for what happened. I think I mentioned on Monday, Mr. Newmeyer has been in custody on this case. I think I said 31 days. The majority of that was waiting for extradition in Ohio. Obviously, I think this could have been a situation where Mr. Newmeyer appeared virtually. We reset this court date so he could get here in person and resolve this case to the plea. That was our hope all along. Unfortunately, what happened here. But I don't want that to take away from the fact that Mr. Newmeyer has taken significant steps to change himself for the better. And so for all those reasons, Your Honor, we're asking that the court not impose any jail. And if the court is inclined to impose jail, that Mr. Newmeyer get credit for the 31 days as a sanction and serve no additional jail time. Mr. Newmeyer expects to report to probation today, do whatever is asked of him, and he does have a flight back to Ohio for tomorrow. Obviously, there may be a world in which probation does not let him transfer his probation right away, but Mr. Newmeyer has an additional support system here in Denver if that were to be the case. I'll close by emphasizing, again, we agree with Mr. Aziz. Mr. Newmeyer and the listed victim in this case do not know each other. I think there's no reason to believe they're ever going to interact again. And so we would ask that the court impose no further jail. Thank you.
Sir, you have the right to tell me anything you'd like me to know.
Hello, Your Honor. I understand that I did what I did. I asked no jail time, like my attorney asked. Any restitution, I'm willing to pay it. If he needs anything for medical bills to, flight tickets back here to see his, significant other, I'm willing to pay it. I just asked that no jail time. I'd like to be home with my family.
I'm sure he'd like not to have brain injury for the rest of his life. There's no possible way you don't do jail on this. None. The only reason I'm even accepting the deferred judgment and not sentencing you to prison is in this country, we do look at intent and we do look at the extent of the injury. And in this case, there's no doubt you absolutely intended to punch, but I don't think you actually intended this extent of injury. which is the only reason I didn't reject the deferred judgment. That being said, call it an unlucky punch. You have fundamentally changed this individual's life forever. And I have hardly heard a greater, how do you put it? When your attorney said you're taking classes was unlikely to help repair the victim, there's zero possibility that you're taking classes does anything to help this victim. So 2 years from now, you're going to walk away from this free and clear with nothing but a misdemeanor conviction, and he's going to live the rest of his life with a brain injury because you randomly picked him out of a crowd. So yeah, you're going to do jail time. Other than that, I'm going to grant the motion for the summary judgment. It will be supervised by probation for a period of 2 years. The review date is December 17th, 2027. You're going to have 2 years of probation on the menacing count concurrent. I am imposing the extradition costs. Which is the other aspect of this. I have absolutely no idea. But that is amount in $3,001.30, 3001.30. Those are assessed to the defendant. I'll tell you right now, my intention, and I'll leave notes in the file to this extent, that if you violate this, not only will the felony conviction enter, but you're going to do 364 days in jail on the misdemeanor, and then you'll do prison consecutive to that misdemeanor. And I do that for a very specific reason, to use up all of your pre-sentence confinement credit. Because what you did in this case earned a full prison sentence. You are getting credit. The DA is giving you credit for a lifetime of no prior criminality. But good God, man. Absolutely unacceptable conduct. And then to have done this to this person, you're not going to be there paying his bills. You're not going to be there making up for his loss of income. You're not going to be there for the rest of his life to take care of any of this. So I'm going to give you 60 days in jail, no credit for anything that you've already done. You'll be remanded. When you get out, you'll need to report to probation within 48 hours of your release. We will determine restitution within 63 days. If we'll need a number for restitution within that 63-day time period. If there's an objection to the restitution, Mr. Hall, you need to file a written motion objecting, stating the grounds for the objection. If there's going to be ongoing restitution, prosecution, you need to file a motion justifying that as to providing good cause as to why we can extend the time period for the extension of the ongoing restitution, and just make sure you do that by the numbers.
Yes, Judge.
Mandatory protection order remains in place. So, sir, you are to have no contact directly or indirectly with the victim. This is a VRA crime.
But he just got sick and now he has no job? That sucks.
Mr. Newmeyer, I don't know if you are a gun owner, but during the pendency of this deferred judgment, you are a convicted felon. And states have laws on felons possessing weapons. There are exceedingly narrow exceptions to this prohibition. And if you think at any point in the next 2 years before you withdraw the plea that you need to have a firearm, you better have a long talk with an attorney over what that needs to look like. In addition to no new law violations, whether it's more anger management or anything else, your probation officer may order other terms and conditions. Those will be orders of the court. PR bond is released. And good luck, sir.
All right, Judge, thank you so much. We didn't get to the new judge today, but don't worry, I still have it. We can do that at another time. Okay, I'm going to set up OJ. Thank you so much for coming out today, guys. I really appreciate it. I hope you guys have a great day. And I will see you all in just a little bit. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for